gentlemen, it is 12:30. I know you've been here since around between 9:30 and 10, some of you. So I'm sure you're a little bit hungry by now. So what we're going to do is we're going to take our lunch break and we'll give you an hour, and then we'll start with witnesses for the rest of the day. So, during the recess, you're admonished not to talk or converse among yourselves or with anyone else on any subject connected to this trial, or read, watch, or listen to any report or commentary on the trial of any person connected with this trial by any medium of information, including without limitation to newspapers, television, the internet, and radio, or form or express any opinion on any subject connected with the trial until the case is finally submitted to you. Thank you, and I will see you outside the front doors at 1:30, please. Thank you.
All rise for the exit of the jury.
So we are outside the presence of the jury. One thing that we were talking about, and Mr. Davis, I wanted to let you know, we're talking about what's referred to as the Tavares instruction. And so you remember that pursuant to my previous ruling, what's referred to as other bad acts are coming in, right? Those
Right.
other two girls are coming in. So what the law says is you are entitled to what's referred to as a limiting instruction. And the limiting instruction, I'm going to provide you guys with some paperwork in a moment, but the limiting instruction basically tells the jury, hey, you're going to hear some evidence that's not charged in this case. You can't just hear that and say, oh, Mr. Davis is a bad guy, okay? What the instruction would say is, evidence that the defendant committed offenses other than for those for which he is on trial for, if believed, was not received and may not be considered by you to prove that he is a person of bad character. However, in a criminal prosecution for a sexual offense, you may consider prior sexual bad acts for propensity purposes. You must weigh this evidence in the same manner as you do all other evidence in this case. So that's the limiting instruction that the jury receives, so that they know, hey, you can't just use this and hear it and say, oh, he's a bad guy. It's up to you, though, whether or not you want that instruction to be given. Some people want it to be given, and some people think it draws extra attention to it.
I want it given.
You want it given. Okay, great. So what I'm going to do, Ms. Collins, Mr. Davis, and Mr. Klaus, is the Franks case. If you remember, prior bad acts used to only come in under 48, is it 045 or 035? I can't remember off the top of my head.
045.
What is it?
045.
Yeah, they used to come in under 480545 section 2, where you would need a Petrocelli hearing, and it could be for like motive, intent, lack of mistake or accident. When the legislature changed in 2015, it allowed this to come in basically it added section 3, which was then interpreted by the Franks decision, 432 P3D 752. And what Franks says is, if I could just read it, so I want to make sure we're all in the same page. But it says, before admitting evidence of a prior bad act pursuant to NRS 480452, this court determined that the district court must hold a Petrocelli hearing outside the presence of the jury to determine that 1, the prior bad act is relevant to the crime charged and for a purpose other than proving the defendant's propensity, 2, the act is proven by clear and convincing evidence, and 3, the probative value of the evidence is not substantially outweighed by the danger of unfair prejudice. As discussed, however, NRS 480453 unambiguously removed prior sexual acts from the previous NRS 48045-2's ban on propensity evidence. Therefore, the Petrocelli framework established for admitting evidence of a prior act for purposes other than propensity is not applicable in cases where the state seeks to present evidence of separate acts constituting sexual offenses for purposes of showing propensity in a current sexual offense prosecution. So basically what I'm saying is we used to use the Tavares instruction that said you can't consider this for propensity purposes. But with NRS 480453, the Franks decision completely changed that. So the normal Tavares instruction that we would give is not applicable for two reasons. Number one, it's not the state of the law anymore, and number two, we didn't have a Petrocelli hearing because Ms. Collins has never said, hey, I'm admitting this for, we had a hearing in regards to, because I said, hey, Franks doesn't say we need a hearing. I said, we'll have that because, so I guess I should start with this. Ms. Collins, was it your, I apologize if I got this wrong. I always thought it was your intention to bring it in under 0453 for propensity purposes.
It was, and I agree that Franks doesn't require a hearing. I just think in some of these cases, it's a cleaner process to have a record of that before it gets in front of the jury. So I understand that the Petrocelli is not required, but that was state's preference.
Right, so I guess what I'm asking you though is the Petrocelli hearing is required when you're, and you have to meet those three prongs, when you're trying to do it for motive, intent, lack of mistake, or accident.
Correct.
It was my understanding that that's not what you were doing. You were doing it for propensity purposes, and we were just having a hearing out of the abundance of the caution, so I could understand the acts and make that relevant, make the determination.
Correct, and my motion did not request it for any other purpose, Your Honor, other than propensity. I didn't do it under the other factors.
Okay, so which brings me back to the normal Tavares instruction that would say you are only to consider this for intent, motive. That would no longer be applicable because that's not the reason it's being offered. It's for propensity purposes.
Yes.
Thus, the instruction that I was discussing with you all, evidence that the defendant committed offenses other than that for which he is on trial, if believed, was not received and may not be considered by you to prove that he is a person of bad character. However, in a criminal prosecution for a sexual offense, you may consider prior sexual acts for propensity purposes. You must weigh this evidence in the same manner as you do all other evidence in this case. So basically just explaining why we're not doing the motive, intent, other bad act language, because it's not appropriate in this case.
But her whole argument was the bad acts. The whole motion that she put in was the bad acts motion.
Yeah,
So
no,
basically,
go ahead.
Your Honor.
No, so what I'm saying is she's not saying they're not bad acts, but you can admit bad acts for many different reasons.
Yeah, and now she's saying prescriptive, whatever she said.
Propensity.
But propensity. So that basically throws out her motion to put in the bad acts, which is what she got approved on the motion.
Right, no,
But now
so
we're
propensity
saying propensity.
is a bad act. So there's motive, intent, lack of mistake or accident, there's a couple of them, and then propensity is one of the other ones. So she's adding it for the subsection 3, the propensity, yes.
Your Honor, I'm gonna need some kind of electronic device. You promised me, and I don't have any electronic devices to get my emailed stuff that I need for this trial.
What emails do you need?
Well, with my standby attorney, he sends me, like basically law codes and stuff like that. He sends it to me, and plus I need to contact my witnesses because I could be, if we make it, I could be bringing up a witness to
Oh,
this.
no, sir, we're not gonna get to your witnesses until far into next week.
Oh, okay.
Yeah.
Okay, that's.
So,
the
but
phone-
in
the phone.
regards to your phone, if you need to research any laws or any statutes, Mr. Klaus has his iPad. I can't do anything about your phone right now, sir, because you're in custody and I don't have any access to it. But if you need case law or statutes, Mr. Klaus would be happy to help you.
Your Honor, I think having my own electronic device.
Sir, no one in custody ever, there's no law that says you get an electronic device. No
Okay.
one in custody ever has an electronic device. If you need something, your standby counsel can help you.
You afforded me one, Your Honor.
I afforded you what?
You afforded me a phone. You told me.
No, I said if we need to get specific numbers off your
Okay,
phone to
okay,
provide for the
okay.
witnesses, I'm
I
happy.
misspoken now. I'm sorry.
Okay, that's okay,
So,
alright, go ahead.
his tablet, I can look at his tablet and.
Yeah, I mean, he's gonna have control over it, but if you'd like to read the Frank's decision, that would be fine. Mr. Klotz, do you have the, do you have the site that I gave? Or would you like it?
Frank, so I sent it to him before you.
Okay, wonderful.
Yes, that's why I was asking for my phone, because I don't want it, it's his iPad, which is nice, and
Yeah,
some
Okay.
people don't like you using their iPads.
so that's great, we'll have all that, and then, and you would like that instruction that I've read now twice, you would like that read anytime we're gonna get into any what's referred to as bad act evidence?
Yes, Your Honor.
Okay, and it'll also be part of the final jury instructions as well.
Your Honor, can I actually get the order of her witnesses? Or I like to know so I don't have to go through.
So that's between the two of you, I don't get involved in that, I can't order her to do that, but that's between the two of you. I mean, I think she's already said who she's calling today.
I don't want to ambush, you know?
You mean you don't wanna be ambushed?
Yeah, I don't want to be ambushed.
Okay, so that, I'll let you guys decide all that off of the record. Is there anything else?
Vanessa,
Vanessa Robson's right?
yes.
Okay, alright, you guys, I'll see you at 1:30.